Next case is Erica GINSBERG KLEMMT versus Sarasota County. And Akeem GINSBERG KLEMMT, excuse me. You may proceed.
May it please the court, my name is Eric Koenig. I represent the appellants in this matter, and I respectfully request 4 minutes for rebuttal.
Okay.
This is a case about limited capacity, unresolved issues, and quite frankly, frustration. This is an appeal of an order dismissing the 6th amended complaint with prejudice and denying a motion for leave to amend for a 7th amended complaint for issues that were underlying a certiorari action but not yet resolved. The facts for this case are fairly straightforward and few, and that's my clients purchased some property in Sarasota County at a tax sale. When they went out and scoped the property and had a survey performed, they found the meets and the bounds and ultimately decided to build a dock on the property. When they submitted all their information to Sarasota County denied the application for, among other things, that parking was not allowed on their own property pursuant to a resolution that had been passed some years back improperly, as well as the boundary dispute had arisen, and that Sarasota County was claiming a large portion of my client's property. And the basis of that was an unrecorded calculation sheet that was maintained in Sarasota County's offices, but not in the public records. My clients moved forward and filed a petition for writ of certiorari pro se, as well as a civil action pro se originally, and moved forward to try to get a quash of the decision denying their dock application. That petition for writ of certiorari was ultimately denied. They had since hired our firm and moved forward on additional amended complaints, and even during this process even made a trip up here in front of the 2nd District Court of Appeals on some of the same issues. But at least as far as this court making a decision back 3 years ago, there was a lot of pleading deficiencies and other types of pleading issues that have since been resolved.
Let me ask you, in denying cert, what did the trial court, the circuit court, find?
The circuit court didn't make any findings of law or fact, but merely that the decision denying the dock application was based upon competent, substantial evidence that it had before it, and that due process was in fact followed.
So that would have necessarily included a determination that the board properly relied on the calculation sheet, correct?
Respectfully, no, Your Honor, and that instead it was that the evidence was sufficient that a decision maker could determine that the calculation sheet could have been proper. There was no weighing of the evidence. It was not compared to the plat that was actually available in the public records, which goes to the Palazzo decision. That the Palazzo decision is right on all fours with our case, and that's just because we have underlying facts that may assist the decision maker and ultimately the reviewing court in a certiorari action to determine what facts are available and whether the decision in here by the Board of County Commissioners was potentially proper or not, or at least it had enough evidence compared to actually ruling on the merits. And here, there was no ruling on the merits as to which is the proper method for determining meets and bounds, whether it's a calc sheet held in someone's drawer in Sarasota County, or is it something that's available in the public records.
And that was how the circuit court framed the issue that was before it on the certiorari, correct? The circuit court framed the claims in the certiorari petition with respect to the calculation sheet, as the calculation sheet used at the hearing was unrecorded and unverified and was used rather than the recorded plat to show a lack of parking to support the application. So isn't that exactly how the circuit court phrased it when it resolved it in the certiorari proceeding?
It did phrase it that way, Your Honor, but it did not weigh the evidence and make a determination on the merits. That similar to the Palazzo case where the 4th DCA reviewed a cert action that was for the denial of a site plan for failing to meet permitting requirements, with a civil action claiming that the city had waived the same permitting requirements. That it really was a lot of the same facts, and it does get intertwined, Your Honor. I have to admit that a lot of these facts are in fact relevant as to both avenues. But what we're missing here is an adjudication on the merits. That after the dock was denied, the permit was denied, and the certiorari court ultimately denied the petition for writ of cert, now my clients have a question. Are they allowed to park in front of their property based on a resolution that was improperly passed? Who owns the property that my clients are claiming and Sarasota is claiming? There is no order, there is no judgment on the merits of the case, which under Palazzo and under a variety of cases that we cited in our briefs, the certiorari court cannot make those determinations. It's not weighing the evidence, it's merely looking at it to say, for example, could a jury have possibly found in a certain direction? Not reweighing the evidence, but instead, is this based on competent evidence? Is it the right decision? Is it the best decision? Is it a legal decision? That's ultimately for the new civil action. And here, my clients are without a remedy. That's the big issue here, that had the cert court been empowered to make that decision to say the calculation sheet compared to the plat must prevail, or the parking resolution passed the day before the quasi-judicial hearing without any notice must fail as a matter of law.
Well, let me ask you this. I'm not sure if this is the direction you're going, but I'm trying to understand your argument. Are you basically saying that a resolution in a cert proceeding is never dispositive on plenary review because you're always asking a different question? In other words, could you raise the exact same issue on plenary review as you raised in the cert proceeding, and the cert proceeding would never foreclose you from doing that because you're reviewing for different, even if it's presenting the exact same question, you're looking at it in two separate ways. Is that what you're arguing?
That's exactly what I'm arguing, Your Honor, is that there are different standards. The standard for the cert court is, was there enough evidence that the decision maker could rely upon in rendering its decision? Is it substantial? Is it competent? Not whether they were right or wrong, not whether they made a potential error. Is there enough evidence that it could have ruled in that favor? While the civil action is which one prevails on the boundary dispute, which one prevails on these parking resolution issues. And under the holding of Palazzo and its progeny, that when there is an allegation of governmental wrongdoing, there will always be a cause of action.
Well, Palazzo seemed to me to talk about different issues, that there are certain issues that you raise in the cert proceeding and they don't necessarily foreclose other issues that are only appropriate, I guess, in a separate civil action, or I keep talking about plenary review, but basically in a separate civil action. Here, we don't have that. We have the same claims being raised in both proceedings, and you're just saying that the way in which they are reviewed are different, and that to me is distinct from what the holding in Palazzo was.
Not necessarily, Your Honor. In fact, Palazzo goes even farther, because Palazzo goes to the waiver of a permitting requirement that's actually part of the application. So it was dead on the same issues to be resolved, and arguably the civil action, bless you, Your Honor, would immediately undo the cert action. And that was deemed to be proper because the claims are different. In our cert action was merely to quash the denial of the dock application. In our civil action is to resolve the unresolved issue of who owns certain property and whether these parking resolutions are in fact binding. The cert court was never empowered with that decision-making authority to rule on the merits and the line of case law that stand for that proposition, that it could not make those decisions. All my clients want is a decision on the merits. And to be honest, I don't think they care who makes it. The problem is they didn't get that decision in the cert action. And I do agree with Your Honor that it looks as though we're trying to get two bites at the same apple, when we're not. It's The one decision was, you know, the Board of County Commissioners made its decision. There was enough evidence to make that decision. However, the merits of the case require additional discovery, additional rules of evidence, additional information to make a determination. And while the cert action was so narrowly focused in scope and power to that cert court, it could not make those decisions on the merits. And again, that's where the frustration arises, that my client's now reading that cert case is still unsure what property they own versus what Sarasota owns and where it can and cannot park. And that's all this case has ever been about, from their pro se actions moving forward to once I got involved to help clean up the pleadings. And certainly it sounds like you still have some questions that we're trying to narrow it even further, is what they want is a resolution. And the cert court did not and could not have the power to resolve those issues. And that's all we're looking for today. With regard to some of the issues raised and arguments raised on in the answer brief by Sarasota County, was that Gagnon was raised again and again and again as being the dispositive case. However, Gagnon dealt with submerged land subject to the Butler Act, and that there's a Florida administrative code that provides a very clear line of steps in order to clear title of those properties, or there's a civil action for quiet title to do the same thing. So it's asking for the same relief in two different causes of action that the court in Gagnon, this court in Gagnon, said, well, that's improper. You're truly getting the same bites at the apple. And notably, in the civil action before your honors today, there is no request to undo the decision or otherwise quash the decision of the Board of County Commissioners for the dock application. The only reason the dock application is relevant to any of this is that's how my clients found out about the parking resolutions as well as the boundary dispute. So it's not a second bite at the apple. If this court reverses the trial court and we go back and there is a decision ultimately on the merits of the case with the trial court, it doesn't change what's happened with the dock application. The dock application's been denied. Now, my clients may take another shot at another application for the dock application, but as stated forth in all the briefs, is the dock application was denied for a host of reasons, not just because of the boundary disputes or the parking issues as well. But can it affect it? To get back to your Honor's question, it might. But it's no different than in Palazzo. That is, in the Palazzo case, it was dispositive. Here, it might be relevant, but again, it's an unanswered question. In addition to that, there are some arguments contained in the answer brief that the parking resolutions is a red herring, that any issues involving these resolutions passed both several years ago as well as recently have no effect or bearing on the dock application. And this was what was stated in the answer brief. Well, this only further justifies this appeal, that it's either part of the dock application, in which case it supports the argument that the civil action is improper, or it doesn't, and in fact the answer brief just goes on the merits of why the parking resolutions were properly passed. And again, there's been no determination. You can't have a heads I win, tails you lose, that it is relevant for this purpose, but it's irrelevant for other purposes. It's an issue, and it needs to be resolved. And with regard to Palazzo, the answer brief basically, to summarize, said, well, in Palazzo there was no argument about claim preclusion or res judicata, and that's why this court should really ignore the findings and rulings in Palazzo. Well, just because it hadn't been raised, and I would put to this court, it shouldn't have been raised, that there will always be a claim against a governmental organization if there are allegations of wrongdoing. And here there are allegations of wrongdoing both in passing parking ordinance or parking resolutions rather than ordinances on my client's property, especially the day before the quasi-judicial hearing on the dock application, as well as purposefully hiding or otherwise concealing this calculation sheet from the public eye, while at the same time selling to my clients at a tax deed sale this property, and then later coming back saying, no, you don't own what you think you own pursuant to the recorded plat or what's physically out there. It's limited to what's contained in our calculation sheets. And for those reasons, unless this panel has any additional questions for me, we respectfully request that you reverse the trial court's dismissal with prejudice of the second amended complaint, as well as the order denying the motion for leave to amend the seventh amended complaint that includes not only the declaratory action, but one for ejectment and quiet title. Thank you.
Thank you.
May it please the court, my name is David Pierce. I'm Assistant County Attorney here representing Sarasota County, the appellee in this case. This case does involve a dispute that began after county staff denied a dock permit application by the GINSBERG-KLEMMT. It's important to recognize what happened after that occurred. There was a specific determination by the GINSBERG-KLEMMT, an affirmative decision, to appeal that decision to the Board of County Commissioners, sitting in their quasi-judicial capacity. Okay? So the original dispute involved a discrepancy between two different surveys. The GINSBERG-KLEMMT survey, which estimated approximately 1,541 square feet of upland on their property versus 400 square feet associated with the county survey. And they specifically elected to pursue that remedy with the Board of County Commissioners. And so this case is like the Gagnon case. In that case, there was a discussion by this court as to the option of election of remedies. Okay? There was an election of remedies as to whether you go to circuit court in order to quiet title versus go to a DOA proceeding involving the Board of Trustees of the Internal Improvement Trust Fund. So you do have that affirmative election, and it's in the record specifically where the GINSBERG-KLEMMT noted that they had that option to seek that alternative administrative remedy. And it's in a communication in the record on page 487 of the record.
What about the argument that at this point they are no longer challenging the denial of the dock permit, and this is a separate action seeking declaratory relief so they know what their rights are vis-a-vis the property?
I think the circuit court did resolve the issue as to what they can do with that particular property. The circuit court did resolve the issue as to where is the boundary line. Okay? The boundary line of the right-of-way is, has been decided, and necessarily it was decided first at the Board of County Commissioners level because the GINSBERG-KLEMMT made that optional choice to seek relief at a quasi-judicial hearing. Okay, so you have that distinction where, the GINSBERG-KLEMMT have made arguments that, because we can't seek the same relief in a certiorari proceeding versus a declaratory judgment action, I should be allowed to proceed with my declaratory judgment action. But this court has specifically held that if an issue, and we're talking about collateral estoppel versus res judicata, or issue preclusion versus claim preclusion, okay, you have the same issue that was raised both in the quasi-judicial proceeding below, and then in the certiorari proceeding, and then finally in the declaratory judgment action. And the dispute, the central dispute in all three is the location, the boundary of that right-of-way line. Okay? So that issue was affirmatively resolved first by the Board of County Commissioners. They weighed both surveys and looked at both surveys that was in their record of the proceedings. It was specifically argued by the GINSBERG-KLEMMT at that quasi-judicial hearing, and that transcript is part of the record as well. It was argued in the certiorari proceeding. And finally, it was argued in the declaratory judgment action. And just as a reminder, I've cited in the county's brief the case of Snyder, the Snyder decision from 1993. It's a Florida Supreme Court decision that talked about certiorari review. What is certiorari review? Okay? We're all familiar, of course, with the three prongs of certiorari review. The central prong is essential requirements of the law. Okay? And one of the components of essential requirements of law is just not looking at, did you meet the permitting criteria for a dock? It's also, as discussed by the Snyder opinion, Was the county's decision, okay, was it either arbitrary or discriminatory or unreasonable? So all three of those things occur during certiorari review. So it's not just can you quash the decision below. That's the end result, but one of the things that a circuit court must do on first-tier cert review is look and determine, now there's a shifting burden that occurs there, have you met the permanent criteria to begin with? And if you have, then the burden shifts to the county to demonstrate the decision was not unreasonable, discriminatory, or arbitrary. So it's not simply as the appellants would describe that situation to you, that there is no sort of looking at the issues of the proceeding below. And again, the case that kind of makes that clear is Neapolitan Enterprises, LLC, versus City of Naples. It's 185 Southern 3rd, 585. It's a decision by this court back in 2016, and it essentially, when a circuit court in a certiorari proceeding makes an actual determination on an issue essential to its decision, which we have here, and a plaintiff raises that same issue in a new lawsuit, collateral estoppel will bar relitigation of that issue. So we have an affirmative determination by the circuit court when it looked at that second amended petition for writ of certiorari. No, there's nothing wrong with that, the use of those calculation sheets. And it was explained by the county surveyor during that quasi-judicial proceeding the reason why they relied upon those calculation sheets. And there's a perfectly reasonable explanation why. The plat in this case was created back in 1926. Okay? That plat, as explained by the county surveyor, must have been some sort of sales plat. Doesn't have any sort of center line associated with roads, doesn't have any radii, doesn't have any curves. So you're talking about a situation where the original developer in that particular subdivision created calculation sheets. The county surveyor had those calculation sheets in her office and reasonably used those calculation sheets. The Florida Rules of Administrative Procedure, Administrative Code require a county surveyor or any surveyor to use the best information available to them. And that was something that was discussed and litigated over in those certiorari proceedings. So again, let's look at what did the trial court do with this particular case. Why did the trial court do what it did regarding the Sixth Amendment complaint? We all know that a defendant may raise affirmative defenses based on the four corners of the complaint, okay, or the attachments. And the trial court must confine its review to those four corners of the complaint and deciding, do I dismiss or do I not dismiss? When a complaint specifically incorporates by reference the prior proceedings such that a trial court has before it a complete history of this litigation, the trial court may dismiss the complaint based on issues of res judicata or estoppel. And again, that's that Neapolitan Enterprises case by this court in 2016. So the question to be answered is, by the trial court in this court, where in that Sixth Amendment complaint is there a reference to the same collateral issue of a boundary dispute raised in the quasi-judicial proceeding and in the certiorari proceeding? Within its four corners, the Sixth Amendment complaint refers to the calculation sheets that are the heart of this dispute, and that's in the record at pages 1225 and 1226. The Sixth Amendment complaint also specifically refers to the board's quasi-judicial hearing on December 9th of 2015 in front of the Sarasota County Water Navigation Control Authority, which is also the Board of County Commissioners. And the Sixth Amendment complaint also specifically refers to the petition for certiorari denied by the circuit court in the record at page 1227. So this matter is this case has been to this court on one prior occasion, as we all know, and we were here a little more than 2 years ago. On August 16th of 2017, this court affirmed the dismissal of the first two counts of the amended complaint in the case. What was in those first two counts? Well, there were requests for declaratory relief, and the first was regarding the use of the calculation sheets and the boundary of the right-of-way, the delineation of the boundary of the right-of-way. And the second count was a declaration regarding the Marketable Irrevocable Title Act in association with those calculation sheets and the right-of-way boundary. The third count of the complaint was dismissed without prejudice by the trial court, and that had to do with a no parking resolution. Okay? Judge Casanueva, in his opinion, a little more than 2 years ago, wrote, to the extent the trial court's order is dismissed with prejudice, those matters that are probably the subject of the pending certiorari petition, we affirm. And the court also wrote, the Ginsberg-Clements were afforded the opportunity to replead in proper form such causes of action as they may deem appropriate, including a claim that the actions of the county constitute regulatory taking, which they haven't done here, or such other causes based on statute. Again, we don't have a statutory cause of action. We don't have a consistency challenge under Chapter 163 of the Florida statutes. We don't have a Burt-Harris Act claim under Chapter 70 of the Florida statutes, or such other causes of relief as may be deemed appropriate.
Let me ask you this, because counts 1 and 2, well, not so much necessarily 2, but certainly count 1 of the amended complaint was regarding the use of the calculation sheets and delineation of the boundary of the right-of-way line in the context of the permitting proceeding, correct?
Yes, Your Honor.
So, to the extent that they were trying to raise that claim in the cert proceeding and in the civil proceeding, it was the same claim, just in different proceedings. It depends on whether you consider the claim to be the cause of action, the relief, or whether you're talking about the same issue. It is definitely the same issue, so we definitely have collateral estoppel. The question is it res judicata? Is it res judicata if you have a different cause of action? One is a certiorari petition versus 2, a declaratory judgment action. So you may not be requesting the same relief, but it's the same issue, so it's collateral estoppel or issue preclusion as opposed to necessarily res judicata. So the issue that was necessarily resolved in the cert proceeding is that the board did not err in relying on those calculation sheets in denying the permit.
That's correct, Your Honor.
Okay. But your position is that necessarily decides that those calculation sheets are the correct representation of the boundary?
That's correct, Your Honor.
Okay. And why is that why is that so?
That's so, if you're asking about the rationale for the county attorney, the county surveyor, as to why they use those particular, those calculation sheets, again, we talk about a plat from 1926 that doesn't have the correct bearings, it doesn't have a center line, it doesn't have the correct radii, it doesn't have the correct curve information. So, as explained by the county surveyor, if you were to plat, or if you were to survey and create a survey using only the plat, you would end up with property lines in the wrong location, the boundary of the right-of-way line in the wrong location. So the original developer of the subdivision had a surveyor, and the surveyor did these calculation sheets that basically did more than just doodle and draw the plat.
Let me stop you there, because I'm not asking so much for you to go into the merits, I don't think, of it, because that is how you would argue the merits of whether which one is correct and which one isn't. But I guess what I'm trying to get at is how, just looking at the face of everything that we have, the cert petition, the ruling on the cert petition, I mean, how do we know, and I apologize if I'm not articulating this right, but isn't that something that would have to be played out in a civil proceeding as opposed to the starting point in the civil proceeding?
Are you asking about the procedural posture?
I think so. I think what I'm trying to get at is, again, how is, I think I'm still having a hard time seeing how the determination that was made in the cert proceeding necessarily implicates, as I think your colleague calls it, the merits argument of which one actually is correct.
And I think that goes into the question, going back to the Snyder decision and the ABG decision that was cited by the appellants in their brief. They talked about how a decision made by a quasi-judicial entity, in this case the Board of County Commissioners, cannot be arbitrary, cannot be unreasonable, cannot be discriminatory. What they were essentially arguing by saying, Board of County Commissioners, when you were relying upon those calculation sheets and the county surveyor's testimony, you were acting arbitrarily, you were acting unreasonably. So a ruling by the circuit court and saying, no, I don't see it. The Board of County Commissioners acted properly in the instance, necessarily gets to that issue on the merits. If that explains, hopefully that explains the situation, Your Honor. Now, very briefly, just to talk about the parking resolution. What the GINSBERG-KLEMMT did in their 6th amended complaint is they combined that issue regarding the calculation sheets and the boundary of the right-of-way line with a parking dispute. So they lumped it all into one count, single count in the 6th amended complaint. Whereas in prior iterations of the different complaints, they had separated those out. Like the amended complaint that was here 2 years ago, they had that separated out into separate counts. So what was the circuit court supposed to do other than, based on the law of the case doctrine, based on collateral estoppel, other than dismiss that 6th amended complaint? And also, as pointed out in the answer brief, they fail on the merits. It's perfectly reasonable for the Sarasota County Board of County Commissioners to pass an ordinance that delegates responsibility to staff and to a traffic advisory council decide where a no parking zone would be located. And that's the Tell case that I've cited in the answer brief, where you have that proper delegation of authority with certain standards. And those standards look at Chapter 316 of the Florida statute, so it incorporates those by reference, and determines whether or not you're creating some sort of traffic hazard. That determination is first made by the Department of Transportation, the County Transportation Department, and then they take that to the Traffic Advisory Council, which holds a public hearing, and decides yes or no. Let's make a recommendation to the Board of County Commissioners on whether there should be a no parking zone. And then after that Traffic Advisory Council makes that recommendation, finally the Board of County Commissioners approves that decision through a resolution. And as I've pointed out in the answer brief, these aren't the only determinations that are made by resolution. You have parking signs. You have railroad crossing signs. You have speed limit signs. All of those things are made by Board of County Commissioners by resolution. You're talking about an administrative process here. And unless the panel has any additional questions, I would simply ask.
I had a question going back to the discussion prior to the parking issue. Does it, for issue preclusion, does the issue have to be dispositive of that matter? In other words, the matter at hand was whether there could be a permit for a dock. If the circuit court said, well, there was competent substantial evidence to support one ground for denial, which was the boundary dispute, if I'm correct. And maybe I'm importing concepts from judicial estoppel, but if that was one of many grounds, does that not undermine your issue preclusion?
I think what you're going to, Your Honor, is for issue preclusion, you have to have the three elements that we all recognize. One, identity of parties, which we have here. Two, the particular matter must be fully litigated and determined, which I think that particular issue was fully litigated and determined, not just in the certiorari proceeding, but again, the Board of County Commissioners conducted that quasi-judicial hearing, and administrative res judicata applies universally in Florida courts as well. And then three, the issue must be critical and necessary part of the determination. And if you look in the record of the proceedings below, in the amended petition for a certiorari, the GINSBERG-KLEMMT specifically said this is a critical issue. So I think, to answer your question, I think that determination
was it critical and necessary? I mean, if the board had other reasons for denying the permit?
I think no, I think if there is any particular reason why the board can deny, if they don't meet any of the permitting criteria, the Board of County Commissioners can deny the dock permit application, but it certainly was an important issue. And with that, I'll simply ask that the court affirm the decision below. Thank you.
Thank you. We have a few minutes left if you care to use them for rebuttal, counsel.
Thank you, Your Honor. So I'll just touch on some of the points that was discussed up here, and that first and foremost, the idea that, well, if this was an issue that was raised in a certiorari action, it can never be raised in a separate civil action, where Palazzo and his progeny say exactly the opposite. What those cases stand for is that the cert court is truly limited to only deciding the one issue before it. And the one issue, the one claim, was the denial of the dock permit. And based on Sarasota County's arguments today, it's exactly the opposite of what Palazzo stands for. And that's, well, if you bring an issue before, on a petition for writ of certiorari, and the court upholds the decision, and the decision was based on 100 factors, well, now we have a ruling on the merits of those 100 factors, whether they were truly dispositive, or whether they were relevant, or whether they were helpful. So based on Sarasota County's position today, the laundry list of reasons that Sarasota County denied the dock permit application, that ultimately the certiorari court denied cert, well, that means these are now dispositive issues determined on the merits. And under the current case law, that cannot be the case. And that in Palazzo, the dispositive issues of whether there was waiver of permitting requirements, whether there was an estoppel based upon the city's own wrongdoing. We have the identical issues before this court today, and that's basically an estoppel of its own improper conduct, of it hiding the calc sheets or passing an improper resolution on my client's properties. These are issues that have not been disposed of. The ultimate order denying the petition for writ of certiorari does not deal with the merits. It does not give a final adjudication, nor can it. And that it did not weigh the evidence. It did not determine which one is better, but it was only a matter of sufficiency of evidence. With regard to the GINSBERG-KLEMMT ruling that this court had ruled, to the extent any of these claims were identical to the claims requested in the petition for writ of certiorari, then they would be properly denied with prejudice. But that was not the law of the case. The law of the case, reading through, and I was actually a little bit nervous I'd get a similar, some of the people on the same panel to say, I know exactly what I was thinking going through this, but at least all we have is the written opinion. And the written opinion discusses, look, we don't know what it is you're trying to say, that we don't think you've pled this properly. I think there's a cause of action here, and maybe you can go down, as Mr. Pierce has said, well, maybe just a different cause of action, that maybe this can be a different kind of regulatory taking, perhaps. The problem with that line of arguments, it's still the same facts that form the basis of it. It's the calculation sheet. It's the parking resolutions. It's still a claim of ownership over my client's properties that hasn't been properly disposed of. And finally, with regard to the claims and the issues, is we still don't have an answer. And that there are no rulings on the merits on the issues presented in the 6th and 7th amended complaints. And for those reasons, we respectfully request that this court reverse the trial court and allow the amendment of the 7th amended complaint, and to reverse the order dismissing the 6th amended complaint with prejudice. Thank you.